Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
Is the next search on February 28, 2020? 7:44 p.m. How, does the FBI find people? People's misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
Good evening. Good evening. Oh my goodness, it's great to see some of you. I've missed you all. Where have you been? Oh wait, I know. Sorry. Never mind. Welcome to the Court of Public Opinion. We need a letter reading intro. Whoa, letter reading intro. What does a letter reading intro sound like? I'm curious now. Does it is it more upbeat? Is it more upbeat than that? Is it like I don't know, shall we say louder?
Wake up in the morning wearing headphones. I'm running court into your brain like it's an end zone. My money's green like the pickles and you want some. Don't interrupt cause I don't want your lame objection. From land t-shirts to murder, I think I've seen it all. From picking juries to when the gavel falls. The judge takes the bench and the bailiff yells all rise. And pay respect to the one and only go to true crime. Imitators they try but they just can't achieve. And when they fail they be like, ow, I stepped on a beat. Take the stand and the jury chooses not to believe. Because there will never be another creator like me. Big deal in one corner and the count in another. We've got the judge reading chat while we talk to the lawyers. All our clips go viral, they're too good not to share. Came in late, check the thumbnails, you'll find it all there. They say I'm addicted to rhyme, but it's more than just time. And the mic is hot, the gavel drops, and I'll be talking about crime. And don't you worry about the sound, cause I'm keeping it real. Just like a pickle jar, but I'm one big deal. They say I'm addicted to rhyme, but it's more than just time. And the mic is hot, the gavel drops, and I'll be talking about crime. And don't you worry about the sound, cause I'm keeping it real. Just like a pickle jar, but I'm one big deal.
Okay, so that's the only way we can start a reading stream, I guess. We'll have to do a happy Friday to everybody. Oh my goodness, happy Friday. Welcome. Come on in. I think we have to say welcome, unfortunately. Oh, did I say that part out loud? Unfortunately to Adam Nusky, who's first in chat today. Adam, or what if Adam Nusky. Welcome. Adam's great to have you here. Actually, I'm really glad you won. It's been a while. It's been too long. It's been like a couple of weeks since you've won the internet, Adam. So we're back in capable hands, probably for the weekend, because I'm not anticipating going live again after this. But why are we on Friday night? Better yet, for Mrs. R.A., why am I on during date night? Well, we've got a document to read. We have a document to read. Date night's going to have to shift just a little bit. But welcome. It's great to have all of you here. A couple people I have to give a shout out to. First and foremost, let's see. We have Colleen K, who's a member for 8 months. Is that on the screen? Yes, it is. I think it is. Thank you, Colleen. Congratulations. 8 months. You've almost got the gender reveal. That comes at the 9-month mark. Welsh law student, nearly 1 a.m. here, but I couldn't miss this one. Awesome. Wonderful. 6 months for you. And look at that yellow courthouse. It looks great. JPC, also a member for 6 months. Happy to be here. Thank you, RA. Thank you, JPC, for being here. Appreciate that. And DNB gifted a membership. First thing. So wonderful. Thank you all for being here. Appreciate you. We have a document from the Maya trial. We have JHACH's response. We have JHACH's response to the sanction request, which is where JHACH was accused of all the bad things that we saw them do during trial, or that we believe we saw them do during trial, or we heard were brought up. And here's their reply to the judge. And it's got shade, it's got spice, it's got goodness. So here we go. I have a couple bottles of water. It is about 10 pages. I don't know if all of it's, I haven't even scrolled through. I don't know how it ends. We might have like 1 page of reading, like 8 pages of screenshots. But either way, we're gonna do this anyway. So let's see. Let's turn this one off and this one on. There we go. Can you guys? I want to make it so you guys can read it as well. Oop, that was a little too small. Okay. There we go. This will probably be good. And I'll take it full screen so I can see. For my old eyes. Hang on. Dog Lover says, be sure to find the beep sound. Are we going to need a little bit of beeping? Is there beeps in here? I haven't read that far. All right. Little water. Cold read. Here we go. Take 1 from the top. Screw it. We'll do it live, right? All right. This is... obviously, back in 12th Judicial Court with Maya Kowalski, individually, Jack as well, representative of the state of Beata. Defendant's response to plaintiff's supplement to motion for sanctions. All you need to know is this comes from JHACH in response to what Mr. Anderson and his team gave Judge Carroll to read and consider previously. Defendant Johns Hopkins All Children's Hospital, JHACH, asked this court to deny the plaintiff's supplemental motion for sanctions and consideration of bar referral for defense counsel's deliberate misrepresentations and elicitation of false testimony and other conduct. Can I just stop for just a minute? The funny thing is that, like, procedurally, to respond to this, you sort of have to put the title of the other person's document. And Mr. Anderson called it Supplement to Motion for Sanctions and Consideration for Bar Referral for Defense Counsel's Deliberate Misrepresentations and Elicitation of False Testimony and Other Conduct. And because that's his title, JHACH has to, in their opening paragraph, list bar referral for defense counsel's deliberate misrepresentations and elicitation of false testimony and other conduct, which they're trying to deny, but they have to put it in paragraph number 1, which I think is hilarious. It makes this was next level chess by Mr. Anderson's team. Great job there. Number 1, for the following reasons. Number 1, the motion is an attempt by plaintiff's counsel, here after counsel, to conscript this court. Conscript. Wow. It's like a military term. Conscript this court into service in the personal war. Oh, it is a military term. The personal war counsel is waging against Mr. Hunter, Mr. Shapiro, and Mr. Hughes, collectively defense counsel. The court should view the motion for what it really is. Counsel's attempt to procure a bar proceeding that he prefers, rules regulating the Florida bar, to the one that he would trigger by reporting Mr. Hunter, Mr. Shapiro, and Mr. Hughes to the bar himself. What? He says the court should look at this for what it is. This is Mr. Anderson trying to get the bar called by the judge instead of by him. Because any lawyer can file a bar complaint, but it has just that little extra oomph behind it when it comes from the judge. Right? And they're saying that's what he's doing. JHACH says, clearly, Mr. Anderson could file this complaint himself, but instead he wants the court to do it. Rule 3-7.18 is a product of the weight and deference the bar and the Florida Supreme Court give to grievances that judges, who are presumably acting impartially, take it upon themselves to initiate. So, yes, a judge's complaint has more weight than another lawyer's complaint. There is no provision in this rule or anywhere else that allows opposing counsel to hijack this weight and deference and essentially steal the court's stolen valor, through a motion asking the court to initiate a grievance that the court did not see fit to initiate on its own. Such a motion, if granted, would taint the entire Rule 3-7.18 process with a sheen of partisanship that is at odds with the rule's very foundations. They are gambling. Right here. They are gambling that Judge Carroll hasn't decided in and of himself, if Mr. Anderson doesn't do it, I sure as heck will. Because if that has happened, Judge Carroll can come back with a kick and a half And then you're going to see a little deference and weight on a motion, on a bar complaint. As another trial court faced with a similar motion concluded for reasons that proceeded and are unrelated to Rule 3-7.18 and are discussed in more detail below, granting the motion would be inappropriate. So basically say case law right here. Or as this court noted on September 28th, this is not an issue for me. Wow. This is not an issue for me. Can I get a little context on this one? September 28th, 2023. This is, quote, not an issue for me. Excuse me. That was on 9/28/23, the trial transcript, page 2,599. Lines 2 through 7, Exhibit A. The court should decline counsel's effort to have the court join forces with him in his ongoing personal battle with defense counsel. As far as the alleged misconduct and brief response, the alleged misconduct described in the motion is that, 1, Mr. Shapiro elicited false testimony concerning CMS immediate jeopardy findings. 2, Mr. Hughes disparaged members of the jury in a private post-verdict email communication. And 3, Mr. Shapiro disparaged the trial court in a post-media statement and made a profane outburst while exiting the courtroom during trial. Matter 1 was already briefed and argued. JHACH adopts and incorporates its previous written and oral arguments supporting documents related to this issue. Okay, so matter 1 is the Mr. Shapiro elicited false testimony. That's when the CMS guy was up there and he's like, no, the hospital's great. They have a great record. I have no knowledge of anything else, because he hadn't seen anything. Okay? So that's matter 1. Let's not talk about that one. It says JHACH. We talked about it before, and we don't want to talk about it anymore. Simply stated, and it's exhaustively demonstrated, defense counsel elicited no false testimony, and the complaint made by the plaintiff lacks merit. Regarding matter 2, the communication at issue, is this the bus stop jurors part? The communication at issue was a private email between David Hughes and an anesthesiologist in Boston. That person initiated contact with Mr. Hughes via private email in the post-verdict phase and offered defense counsel valuable information. Without Mr. Hughes' knowledge or consent, the anesthesiologist posted her private email exchange with Mr. Hughes on a messaging platform. According to the anesthesiologist, I wonder what platform that was. Like 3 guesses, first 2 don't count. What messaging platform did they post this to? According to the anesthesiologist, someone on the messaging platform, yes, read Reddit, without Mr. Hughes' knowledge and consent, posted the private email exchange on a social media platform. Plaintiffs apparently located the email on the social media network, attached it to a post-verdict filing, and then falsely accused Mr. Hughes of publicly denigrating the jury. Mr. Hughes' email communication was intended to remain private. He only wanted a few people, select people, to know that he thought they were bus stop jurors. Regarding matter number 3, Mr. Shapiro denies the statements attributed to him, which allegedly occurred in a conversation between him and his paralegal, as described in the affidavit promulgated by Ms. Carlson attached to the motion. Furthermore, Mr. Shapiro's post-trial media statements complied with applicable ethical rules, and he did not make any such statements with any intent to disparage the court or litigants. The intent wasn't there. Judge, I didn't mean it. I know it's out there for everyone to watch, but I didn't mean it to come across that way. Argument and memorandum of law. Counsel contends that he is ethically obligated to report defense counsel's alleged misconduct to the trial court, which he erroneously claims is the appropriate professional authority, referenced in Rule 4-8.3, so the court can then make a judicial referral to the Florida bar. This contention is without merit. The Florida bar, not this court, is the only appropriate professional authority to which counsel is obligated to report any concerns that fall within Rule 4-8.3, and he is free to report defense counsel to the bar. This rule does not require attorneys to report such concerns to judges or to ask judges to report such concerns to the bar. The counsel does not provide any cogent explanation why this court, rather than he, must initiate a bar referral, because there is none. Neither the rules, comments, nor case law require trial courts, in response to a post-trial motion, to act as a litigant's reporting intermediary. Case law, the Theriault versus Asphalt. provides an instructive roadmap. In Theriault, I don't know how to say that word, defense counsel filed a post-trial motion that sought the following primary sanction for opposing counsel's behavior during trial and discovery. Hang on, I missed something here. Hold tight. Shrink. I just noticed you guys are all standing. I have to give you a seat. So give me a second. We'll get the seats running. Okay. I think they should be starting here soon. There we go. All right. In this case law, the defense counsel filed a post-trial motion that sought for the following primary sanction for opposing counsel's behavior during trial and discovery. For the court to specifically refer this matter, I'm using the wrong mouse, there we go, to the Florida Bar for further investigation and disciplinary action. Okay, seats are working. The Theriault trial court declined the invitation. The trial court concluded a judicial referral was inappropriate because trial counsel was free to satisfy his or her reporting obligations with his or her own complaint with the Florida Bar. The trial court further responded that its refusal to report did not impede investigation or further action if trial counsel made his or her own bar grievance. Counsel is fully capable of reporting defense counsel to the Florida Bar without involving the court and the media, but in remarks that themselves disparage the bar with respect to its treatment of grievance referrals by lawyers and violate other rules, counsel revealed his true agenda. Theriault is pronounced Terrio. Terrio. Okay, we're going to go Terrio. Thank you very much for that, Chantel Caesar. We'll call it Terrio. All right. Counsel revealed his true agenda. The big thing that I has always hoped for, and is in this case, which Judge Carroll danced around and a little bit here and there, was, the only thing that really has an effect is when judge refers you to the bar. When a judge sends you to the bar, then the bar will take notice. Where did they see that? In remarks that disparage the bar with respect to its treatment of grievance referrals by lawyers and violate other rules. Where did these remarks come from? Oh, it's a YouTube video. Okay, so that I'm curious, really curious. Let's open this link. Who is it? I want to see where the video came from. Oh, the video's not available anymore. The link is bad. The link is bad. Okay. There we go. That's registration for something else. Here we go. We're back. So bad link, first of all. Oh, wow. There's some asterisks here. I'm going to have to guess what it says. In addition, opposing counsel advised the public that the court and members of the public at large should grieve defense counsel because the Florida Bar lacks the funding and personnel to prosecute birds and random hats like defense counsel. Refuses to tell he's an and does not take the ethics grievances seriously unless they come from a judiciary. Okay, I think I got that one. The court should familiarize itself with the council's post-verdict media campaign, which includes commentary about the motion for sanctions and judicial bar referral sub judice before it rules on the motion. Through the motion, counsel hopes to enlist the court in that campaign. For all these reasons, the court should deny the motion. If counsel truly believes defense counsel should be reported to the bar, he can do that himself. If he does, defense counsel will more fully explain to the bar their defenses to his charges, which are only briefly described in the opening section of this response to the motion. So if Mr. Anderson files the report, then defense counsel will give a full explanation, where we've only just glossed over it because it's not worth anything more than that thus far. Wherefore, defendant Johns Hopkins All Children's Hospital Incorporated respectfully requests that this court deny plaintiff's supplement to motion for sanctions and consideration of bar referral for defense counsel's deliberate misrepresentations and elicitation of false testimony and other conduct. He has to say it again in the closing. Oh my goodness. I hereby certify on May 3rd, I electronically filed the foregoing with the clerk of court using the e-filings through the Florida Courts e-portal system, which will provide a notice of e-filing to counsel of record. And it's signed Ethan R. Shapiro. And here's a copy. This is the, let's see, this is jury trial September. Oh, this is our reference for the Exhibit A. Exhibit A, where are we at? Okay, lines 5 through 7. Okay, what the lawyers say, we're starting right here. What the lawyers say, and you're responsible for the words you say, and whether someone walks themselves into a defamation lawsuit, that's between the two parties, or a bar complaint, that's between, the parties. But that's not an issue for me. So I'm not going to take any action other than what I did this morning, which is to ask them their specific question. And I trust both of you as members of the Florida Bar to comply with the rules regulated by the Florida Bar. This was early on in the court, right? I think there will be other trial transcripts where it goes a little closer to the judge saying, yes, we did that. But, we have more links. Give me just 1 second. Jules, give us a call. Give us a call on the burner. I will watch for it. Sorry, I've had the ringer off. Okay, I think the ringer is on now. Let me first check out some links here. Let's open this link.
One. To send a voicemail.
Hey, Jules, are you there? Oh, man. The first link was to Dr. Joe's welcome video on his YouTube. Okay, the second link, not there. Third link. Oh, this one's going to load, it looks like. Possibly. Oh, it's Dr. Joe as well. Hey, Jules.
Jules.
Jules, can you hear me now?
I can now, yeah. Listen.
Oh, this was
number
Rob.
11.
Rob. Yeah.
Okay, number 11 in the document that you just read, that's a complete fallacy, okay? I was there. I heard what Shapiro said, and that was the first time, though, he made derogatory comments in regards to the family. There were two...
Was this when he stormed out of court?
Yes, okay? That's when he stormed out of court after the verdict, okay? I heard it. I was there. I was directly behind him when that happened, okay?
Okay.
And I turned around and I even said to Alicia, did you hear what he just said? And she said, no, what did he say? And I said, forget it. I didn't even want to go into it. But that's not the first time that Mr. Shapiro had, I'm not going to call it an outburst, but where he said disparaging things about Judge Carroll. On 2 occasions, this was prior to it going to verdict, okay? Mm-hmm. When Judge Carroll, put him in his place, kind of berated him in court, and then he would walk out of court, and he had to walk right past me because of where I was sitting.
Right.
He mumbled, I'm not going to use the word because I know how you are, but effing... there you go. That effing judge. I heard and witnessed that on 2 separate occasions, and this was prior to a jury verdict. This was during the actual trial. Not to mention, what he did to me. Mm-hmm. Okay?
We heard about that one.
Right. So there's that. Now, that first link that you clicked, I don't know why you couldn't get that to pull up, but that's Dr. Joe's December the 7th show when Greg was on there. And did Greg talk about it? Yeah, he did. Yeah. He said it.
I'm trying to open all these links. I've got a lot of them that say they're not available now.
I don't know why they're available for me.
you have like special access. We've got a lot of Rob from Lawn Lumber on there. A couple of those. I'm just seeing what else we have.
Well, the link,
Megan Fox.
the one link,
Megan Fox is
the
on
one
here.
link the one link that's completely by itself, the first one, that's Dr. Joe's link. I don't know why you can't. I don't know why you can't open them. I don't know. I can open them, but in any case, Anderson Glenn law firm. They're all very much well aware of what I heard and what I witnessed. And if I have to, I will, as everybody knows, I've been being very quiet for quite some time now and not participating in a lot of things. But if I have to go public with it, I will, because especially the one where he disparaged the family, because I heard it loud and everybody heard it. Everyone heard him.
Yep. This is I think a weak defense.
Yeah.
It's a very weak defense. They say that they have more they would go into if there was actual bar complaint filed by Attorney Anderson. But mostly all they want is the judge not to file it, because if the judge files it, the bar is going to look at that. I mean, it's going to be like, okay, this rises to the top of the list. We don't often have a judge tell us we've got a problem with this attorney. So yeah, they just want to avoid that. But
now, yeah. And they will, and that is a fact. I mean, Greg Anderson stated that he did state that if it comes from a judge, the bar will absolutely pay attention. Now, I don't know if if the bar will pay attention to a public outcry. I don't know. Will the bar listen to other lawyers? I don't know. But the bar will definitely listen to a judge. Will Judge Carroll do this? Personally, I don't think he will.
I don't know.
I think Judge Carroll just wants this to all go away.
Well, he wanted to make sure he was nice and fair through the ruling, and make sure he didn't create an appeal, right? So he was very, very careful all the way through that. But once this is all over, where we are right now, I'm worried that where they took that little piece out of context on the well, I think it's out of context on the transcript. I'm worried there's a lot more in there. Well, I'm pretty sure there's a lot more where the judge was quite upset with defense for doing things that the judge was insinuating could rise to a bar complaint. And so for them putting words in the judge's mouth and saying, this is not your job, you shouldn't do it. He's like, wait a minute. I mean, I was there. Okay. I was there. I remember, and he's got a fantastic memory. He remembers what happened at a hearing 2 years ago. And didn't you argue this back then?
Yeah, he does. And let's not forget, how many times Greg pissed him off one time where he had to take a 5-minute breather and go back in his chambers. But on 2 other occasions, Shapiro and Hunter really pushed their luck with him, and twice he had to go take his 5-minute break in his chambers because he was going to, have an aneurysm right there. So he knows what they're like, but will he go that far? I don't know. I don't know if Judge Carroll will do it. However, if they're going to have a hearing on it, definitely. I'm going to be at the August 1st hearing. I am going to attend that.
What's the purpose of August 1st? Is that that's the first one after mediation,
Sanctions.
Right? When do they talk about the fact that sanctions or that mediation failed miserably?
May. What date was it? Crap. All right, they had the first one was April 15th. It never got past the April 15th. Okay, they were scheduled to do April 15th and April 17th, and it never got past 2 hours on April 15th.
I want to know what happened. I wish we could see, because there was no deal worked out there, right? But I wish we could know what happened. I like to think in my head. I like to think that that Attorney Anderson, as he got up to start speaking, because he's sort of in charge there, right? Because he's all the ball's in his court at this point. He stands up and he pulls up the Top Market Media live counter of the interest. He's like, if you'll focus your attention on the bottom line here, this $215 million figure, that's where we're starting from.
It's the mediator who is in charge, and from it not getting past not even a 3-hour mark, okay? They didn't even make it to lunch.
Yeah.
Okay? They didn't even make it to lunchtime. It was done and over with before that. Tells me that the mediator couldn't even take charge of the situation. I believe
what if we
that
quit?
Hunter and
the mediator just stormed out. He's like, "Look, you children, I'm not paid enough for this. I'm out."
We'll never know. We'll never know because they can't
secret.
discuss it.
It's secret. They'll take it to their graves, unfortunately.
Yes, but the thing of it is we know Hunter and Shapiro did not want to mediate. They did not.
No.
And
they want to litigate.
They
want to fight and fight.
Yeah. And they want to bleed John Hopkins dry, in my opinion. But they were forced to do this mediation. So I wish I was a fly on the wall on April 15th. But unfortunately, I was not. But I'm going to be there on August 1st for that hearing and see, and see what goes down.
It's going to be awesome.
I don't know.
It's good to hear you again, Jules. I'm glad you're doing well.
Yeah, I'm just
plugging
chilling.
along.
I've been chilling for months. Yeah, but I do watch you. I watch. I'm monitoring 3 trials at once.
That's how you know you're a true crime fan, because you can't leave one to focus on another.
Yeah.
I got another monitor, so I can do more stuff at the same time now. So I'm acquiring.
Well, I noticed that you have been. Yeah.
I've got.
And you've been
utilizing
Top Mark. Yeah. Well, you've been utilizing Top Mark a lot too, I noticed.
Yeah, that's been fun. We're covering the Chad Daybell case over there. We've got some great mods over there. It's just a fun chat, and we've been catching up on the.
That's one.
We've been catching up on the big case, Karen Reed. Oh my goodness, this week.
Yes, I'm doing
the impeachment we've seen. You normally see just like one bit of that in a trial, but it's been like witness after witness after witness. We're seeing some next level impeachment stuff going on, and it's great. I am loving the lawyering in the Karen Reed trial. I have to tell you,
I
have not picked a side.
I don't. Which lawyer are you loving? Which one are you loving?
I've not picked a side. I realize we're hearing one side of it, and it seems weird to see the defense seem to be winning during the prosecution's case. Usually it's the other way. Usually the prosecution, when they present, we're like, yeah, I see the story. It's crazy.
I do have an opinion.
Mm-hmm.
I have an opinion. Okay. I am on Karen Reed's side. Not. Let me explain before people go crazy. I do not believe she deliberately murdered him. Okay? What I do think happened is it was snowing. It was dark. Everybody was drinking. She was
Is that a Boston
made
thing?
a 3-point turn.
Everybody's had a bit too much.
Yeah.
We heard. I'm a few days behind, so I don't want you to spoil it for me because we just barely finished day 6.
I won't. No, I won't spoil anything. But what I'm saying is that she made a 3-point turn in the street to turn around. I believe there is a possibility she may have accidentally hit him.
But
And
8 to
because
20
she was
feet off the
drinking,
road? And a
do
three-point
you
turn?
really believe? I don't know. Okay. But then if you're going with how many feet off the road he was, then you've got to buy into the defense theory that he made it into the house, and that has not been proven to me yet, but that he made it into the house, and a fight took place between him and Higgins, and everybody participated in this huge cover-up. So, I mean...
It's crazy. It's been crazy from the opening, from as soon as defense opened their mouth and said Karen Reed was framed as their opening, their one-liner. I mean, they swung for the fences as soon as they started their opening statement, and it has been trial has not disappointed. I'm fascinated by it. I'm hooked.
No,
I don't know what to believe because we've got a lot of people saying different things. There's like 7 different versions of what Karen Reed said or was yelling at the scene.
Yeah.
It's interesting.
And I'm still waiting on the judge's decision on whether that Caitlin chick committed perjury or not. They're going to charge her for perjury.
I would be surprised if they did. I mean, we've seen some people commit some perjury before, and I've never seen anyone actually get prosecuted.
But this was bold-faced perjury.
It seems to be more egregious in this example than some of the others. But
yes, that was bad. I went to a school with someone by that name. Come on.
Yeah, that
in
was
any
bad.
case, so, that case, Daybell case, and I'm also watching New Jersey. Of course, I have to because it's right in my backyard. And
is that the treadmill one?
And I know some of the I know
goodness.
some of the players.
My heart aches.
In
my
there,
goodness.
so I have to. I've been monitoring. A lot monitoring that one because Tom Zerber and my son unfortunately knows the family. I used the wrong word. I shouldn't have said unfortunately, but my son knows the family. So yeah.
Well, Jules,
in any case, it was nice talking to you,
as
Scott.
always.
Hi, everybody.
we have to head back to Florida. I have to head back to Florida, and we'll enjoy another cinnamon roll between like the 6 of us again.
Why don't you? I know, right? Dr. Joe and I are going to get together soon. We were going to do it on 2 other occasions, but I'm having what you call I don't know what you call it. I'm going through a spell. Let's just say.
Man.
I'm having one of my moments, and I'm just having a little bit of a difficult time of it coming out of it. Don't be sorry. I go through this, every now and then, and this is what it is. But I do love and miss everybody. And if you don't see me in the chat, don't think I'm not watching.
we know you're just a phone call away. Jules, thank you so much. Thanks for calling in.
Love
Appreciate
you guys.
the update.
Bye-bye.
We'll see you. Bye. Love talking to Jules. She's awesome. Got to meet her down there in Florida during the last time, the only time I've been to Florida in my life, because we didn't go to like Disney World or Disneyland. I think it's Disney World down there, right? Never been there. Anyway, quick little thing. I wanted to show you while we're here. We talked about some spicy court things. I've got another video I wanted to show that happened this week as well. Is that Amber on the phone? Amber, are you there?
I'm here. I
You're
was
here.
waiting for you to say my name.
Oh, thank you. By the way, you sent me the links for all the references on that document, and it's other than one professional, I guess you call it a lawyer seminar or something, like continuing education seminar. I don't know what it was. It's basically the people we know and love. We've got Dr. Joe in there several times. You've got Rob from Lawn Lumber. You've got Megan Fox in there. Did I miss anybody?
Yeah, but I don't remember the name of it.
I don't recall either, but yeah. So interesting. It's always fun when your channel gets named in a filing. I hate it personally. I'd rather just fly under the radar, but I appreciate that. I was going to show a quick video if you.
Well, before you move off the Maya stuff, I did send you a couple other things while you were talking with Jules. I sent you the docs and mod chat if you want to look at them. It tells you what motions are going to be addressed in August.
All right.
I also sent you the document of email correspondence, which is not redacted, but it's posted as it's posted on the website. But that's the email correspondence to the judicial assistant of Judge Carroll. and Greg Anderson actually makes a comment about mediation if you care to take a look. So I sent you a couple other things for Maya if you wanted to pull them up and check them out, because that's what you were asking Jules about.
You gave me homework on a Friday night. That's what I'm hearing.
I'm sorry.
That's what I'm hearing. All right, let me. I've got to find, where did I put this video? Did I not? Didn't I put a little video up here? I don't know where I put it. Oh, I put it on Twitter, didn't I? Why did I not post it on YouTube?
Is it in the dryer?
It's not in the dryer. Give me 5 seconds. I'll use the other mouse here. Let's see. I think it's coming out on this one. Here it is. We'll put this one on that screen over there. All right, I wanted to share this. This is a great way to kick off your weekend. If you haven't seen this already, it's choice. Amber, I'll let you go. Thank you very much for the great work. Yeah, you can hang up now. It's good. It's good. We'll see you, Amber. Bye. We'll see you. Bye. All right, wanted to show this little video right here. This is Judge Cedric Simpson, and if you've never watched Judge Cedric Simpson, what rock have you been living under? No, just kidding. He is fantastic. Great judge, very passionate, very, very kind. Also can be stern at times. And in this little clip, Mr. Attorney, Mr. Bennett, who's in the blue shirt and the tan jacket here, is just now, as we start the clip, is just now finishing his statement to the judge, saying, if the shoe were on the other foot, or if the shoe was on the other foot, if I had been the one that filed the emergency motion, there's no way we'd be standing here today, because prosecution gets that, but no way defense would grant that hearing, which is basically, in a few more words, accusing the judge of playing favorites with the prosecution. And I'm not sure if that flies in other courts, but this is the response. It helps if I have audio as well, right? So hold tight. I need to. Forgot I was bringing it on the other computer, which has been linked to different speakers. We're going to back it up. You can see from his face already he's not happy. Okay, let's try that again. Is that working now?
Absolutely. Oh, do not even insult this court by saying that, Mr. Bennett. Do not, because you would have gotten a hearing. Had you filed a motion, had you requested that it is an emergency hearing, the public defender's office does it all the time. The fact you don't know how to do that and think that this court is playing favorites, you're wrong. Court's going to stand in recess.
Cut the break out. He was out for about 10 minutes.
Let me just say this, Mr. Bennett. I've been on this bench almost 25 years, and never have I ever been insulted in the fashion you just insulted this court. No, my turn. The very first case, when you say that defense counsel or anybody else doesn't get access to the court like the prosecutors, you are absolutely wrong. The first case I called today was upon receiving a notification about something that I had considered in a bond, was notified that that had been located. This court, to the defendant's benefit, set that hearing without notice to any side. I set the hearing. So to be fair to all of the parties, I receive motions all the time regarding bond. And this court just seeks to be fair, to have a hearing. Mr. Bennett, if I had had in my heart the desire just to lock your client up, quite frankly, because the decision came from a magistrate under the court rule without a hearing, I could have changed that bond. But I wanted to give the parties the opportunity to be heard. Now, having said that, so maybe you can put that in a little perspective. I heard you that you said you just got the discovery, can't go through it. Well, I'm going to give you about another 18 hours to go through it because I'm adjourning this hearing for two reasons. To allow you to go through the discovery, to give me a cogent argument as to why I should not grant what the people want. And secondly, because you have raised the ire of this court. I am not going to punish your client by what was one of the most ignorant statements I have heard about the conduct of this court from any counsel in all of my years. I will not, by any means, punish him for that. I do not make my decisions out of anger. I'm adjourning this to tomorrow, noon. All the parties are ordered to be here. That is all. That is all.
That is all. Oh my goodness. Love that. I love me some Judge Simpson. Absolutely incredible. I have not seen how that ended. That was yesterday, right? That was yesterday. I have not seen what happened today at noon. We watched for it. He was doing some landlord-tenant stuff. I don't know how it ended. I have no idea. We have to go back. Bennett kept going. Oh my goodness, part two. We'll do part two on Monday. Do part two on Monday because we have to go home. All of us, it's the weekend. The weekend is here. We've watched trial all week long. Oh my goodness. I don't know. I feel bad. Normally Rob is up or Ian is up to take Rob's place and both of them appear to be out of town. Is there somebody we can all hang out with this evening? Let's see who is up. Let me do a quick check here. Do we have some friends that might be live? Uncivil Law is live. Friday Night Thunderdome. Go to Uncivil. The Umbrella Guy is up. Oh my goodness. Needs a warning on that one. Not on the Umbrella Guy, but on the case he's following. Oh my goodness. Let's see. I see Broken Baker's scheduled. I've got Kurt. Kurt is up right now. I haven't been to Kurt in a little while. We'll go ahead and pop over there. He's got Friday Night Thunderdome going on, and we'll jump over there. Come see Ada. Who? Where? Mrs. Kevin, where's that? Where's the? Which channel are you asking me to go see? Yes, Amber C., you're right. The case that the Umbrella Guy is handling. Oh, is she live right now? Why can I not see Etta Brown? I cannot see her on my redirect. She has to turn that setting on. Just message Rob. He has a community post up. I think he's moving. He did a farewell to his shop, so he's leaving. Rob is moving this weekend. It's sad when you have to leave a shop behind, especially wood shop. Although I imagine he's getting a better one. But I'll have to let Rob know I signed a FOIA request and a media access request with his pen today. So thank you very much, Rob, for the pen. All right, you guys, this has been a fantastic week. If you're a fan of true crime, this is the week to be watching. It has been nuts. It's been crazy, and it's not over yet. We have Chad Daybell, who's on day 21 right now, and I have no idea when that's going to end. We're just a couple weeks into the Karen Reed trial, which is going to go 6 to 8 weeks, and that just gets spicier by the day. Obviously, we have some other cases that are going on with the treadmill case. That's a tough one. Emotionally, that's a heavy case to watch. News, if you're following the latest news, we've got stuff from Gilbert Goons all the way up to more suitcase kids cases. Oh my goodness, there's stuff everywhere. If you want to find out, a good place to go over is the Discord page, the As the Gavel Drops Discord page. If you go ahead and put that in chat for us, guys, it's a great place to just check and see what's coming up. Buffer, happy Mother's Day. Quick, guys, what's a good Mother's Day gift for Mrs. R.A.? I don't think she's on right now, so I can ask that. Let's see, have a great weekend. Be great to the wife this weekend. Will do, for sure. I think that's all. Chocolate massage chocolate. There it is. All right, we are going to redirect you over to Kurt. He seems to be one of the only people that's up here, so we'll leave that way. Enjoy your weekend. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again tomorrow morning. No. Tomorrow morning I'm going to be sleeping in. Monday morning we'll be live with, we'll be on day 7 of the Karen Reed trial, which is just, it is crazy. It is crazy. Hope you can join us. Thanks a lot, guys. Have a good weekend. We'll see ya.